Conflict of Laws Incorporation Reviewer. A corporation, according to Section 2 of the Corporation Code of the Philippines, is an artificial being created by the operation of law, having the right of succession and the powers, attributes, and properties expressly authorized by law or incident to its existence, while Section 123 of the same code defines a foreign corporation as one formed, organized, or existing under any laws other than those of the Philippines and whose laws allow Filipino citizens and corporations to do business in its own country or state. Simpyoda, 2004. Conflict of laws with respect to corporations generally deals with laws governing their administration, incorporation, nationality, and domicile. Benito, 2020. Domestic corporation, those organized and existing under laws of the Philippines. Foreign corporation is one formed, organized, or existing under any laws other than those of the Philippines and whose laws allow Filipino citizens and corporations to do business in its own country or state. Its right to lawfully transact business in the Philippines requires two prerequisites. 1. The law of the country of its incorporation allows Filipino citizens and corporations to do business in said country, and 2. It must secure a license to transact business in this country in accordance with this code and a certificate of authority from the appropriate government agency. Agpilo, 2004. Different theories in determining the personal or governing law of a corporation. 1. Law of the place of incorporation. 2. Law of the place or center of management. 3. Law of the place of exploitation. Simpyoda, 2004. The Philippines follows the theory of the place of incorporation in determining the personal or governing law of a corporation. Simpyoda, 2004. In using the place of incorporation test, the nationality of a corporation is determined by the state of incorporation, regardless of the nationality of the stockholders. According to Paras, the two exceptions to the above rule may be given. 1. For constitutional purposes. Even if the corporation was incorporated in the Philippines, it is not deemed a Filipino corporation, and, therefore, cannot exploit our natural resources, and operate public utilities unless 60% of the capital is Filipino owned. 2. For wartime purposes. For wartime purposes, we pierce the veil of corporate identity and go into the nationality of the controlling stockholders to determine if a corporation is an enemy corporation or not. This is referred to as the control test, as distinguished from the incorporation test. Tests in determining the nationality of corporations. UST Golden Notes, 2019, 1. Place of incorporation test, 2. Control test, 3. Grandfather rule. A nationality is attributed to the percentage of equity in the corporation used in nationalized or partly nationalized area. This test is an exception to the control test and was applied by the Security and Exchange Commission in several cases. 4. Domiciliary test. A determined by the principal place of business of the corporation. Domicile of a corporation. Article 51 of New Civil Code provides when the law creating or recognizing them, or any other provision does not fix the domicile of juridical persons, the same shall be understood to be the place where their legal representation is established or where they exercise their principal functions. The domicile of corporations is the place where they have their principal place of business as stated in the Articles of Incorporation. 1. It determines the fixing the venue for personal actions. 2. Corporation not allowed to allege other places of business aside from that stated in the Articles of Incorporation, for to do so would create confusion in determining the venue of personal actions. Control test. In determining the nationality of a corporation, the control test uses the nationality of the controlling stockholders or members of the corporation. A corporation organized, incorporated abroad and registered as doing business in the Philippines under the Corporation Code, of which 100% of the capital stock outstanding and entitled to vote is wholly owned by Filipinos, may be considered a Philippine national under the Foreign Investments Act of 1991. This is the only exception to the place of incorporation test. Security and Exchange Commission Opinion Number 0414, March 3, 2004 de Leon, 2010. This test was adopted by the SET law as a general guideline in determining the nationality of corporations engaged in a nationalized activity. Security and Exchange Commission Opinion Number 0720, November 20, 2007. Control test essentially holds that when shares belonging to corporations or partnerships at least 60% of the capital of which is owed by Philippine citizens, the corporation shall be considered of Philippine nationality. Paragraph 7, Judge Opinion Number 020, Series of 2005, cited in Benito, 2020. In the case of Nickel Mining and Development Corporation vs. Redmont Consolidated Mines Corp. GR. Number 195580, April 21, 2014 provides. Paragraph 7 of Dodge Opinion Number 020, Series of 2005, adopting the 1967 SEC rules which implemented the requirement of the Constitution and other laws pertaining to the controlling interests in enterprises engaged in the exploitation of natural resources owned by Filipino citizens, provides. Shares belonging to corporations or partnerships at least 60% of the capital of which is owned by Filipino citizens shall be considered as of Philippine nationality, but if the percentage of Filipino ownership in the corporation or partnership is less than 60%, only the number of shares corresponding to such percentage shall be counted as of Philippine nationality. Thus, if 100,000 shares are registered in the name of a corporation or partnership, at least 60% of the capital stock or capital, respectively, of which belong to Filipino citizens, all of the shares shall be recorded as owned by Filipinos. But if less than 60%, or say, 50% of the capital stock or capital of the corporation or partnership, respectively, belongs to Filipino citizens, only 50,000 shares shall be counted as owned by Filipinos and the other 50,000 shall be recorded as belonging to aliens. The first part of paragraph 7, Judge Opinion Number 020, stating shares belonging to corporations or partnerships at least 60% of the capital of which is owned by Filipino citizens shall be considered as of Philippine nationality, pertains to the control test or the liberal rule. On the other hand, the second part of the Dodge Opinion, which provides, if the percentage of the Filipino ownership in the corporation or partnership is less than 60%, only the number of shares corresponding to such percentage shall be counted as Philippine nationality, pertains to the stricter, more stringent grandfather rule. The first case is the a-liberal rule, later coined by the SEC as the control test in its May 30, 1990 opinion, and pertains to the portion in said paragraph 7 of the 1967 SEC rules which states, A shares belonging to corporations or partnerships at least 60% of the capital of which is owned by Filipino citizens shall be considered as of Philippine nationality. Under the liberal control test, there is no need to further trace the ownership of the 60%, or more, Filipino stock holdings of the investing corporation, since a corporation which is at least 60% Filipino owned is considered as Filipino. Grandfather rule provides that if the percentage of Filipino ownership in the corporation or partnership is less than 60%, only the number of shares corresponding to such percentage shall be counted as of Philippine nationality. Benito, 2020. To arrive at the actual Filipino ownership and control in a corporation, both the direct and indirect shareholdings in the corporation are determined. In the case of Nickel Mining and Development Corporation vs. Redmont Consolidated Mines Corp. GR. Number 195580, April 21, 2014 provides, the second case is the strict rule or the grandfather rule proper and pertains to the portion in said paragraph 7 of the 1967 SEC rules which states, but if the percentage of Filipino ownership in the corporation or partnership is less than 60%, only the number of shares corresponding to such percentage shall be counted as of Philippine nationality. Under the strict rule or grandfather rule proper, the combined totals in the investing corporation and the investee corporation must be traced, that is, grandfathered, to determine the total percentage of Filipino ownership. Moreover, the ultimate Filipino ownership of the shares must first be traced to the level of the investing corporation and added to the shares directly owned in the investee corporation. In other words, based on the said SEC rule and Dodge opinion, the grandfather rule or the second part of the SEC rule applies only when the 60-40 Filipino foreign equity ownership is in doubt, that is, in cases where the joint venture corporation with Filipino and foreign stockholders with less than 60% Filipino stockholdings, or 59%, invests in other joint venture corporation which is either 60 to 40% Filipino alien or the 59% less Filipino. Stated differently, where the 60-40 Filipino foreign equity ownership is not in doubt, the grandfather rule will not apply. Rules governing the application of the grandfather rule, UST Golden Notes, 2019, 1. The grandfather rule should be used in determining the nationality of a corporation engaged in a partly nationalized activity. This applies in cases where the stocks of a corporation are owned by another corporation with foreign stockholders exceeding 40% of the capital stock of the corporation, SEC OGC Opinion No. 1031. December 9, 2010. 2. The grandfather rule will not apply in cases where the 60-40 Filipino alien equity ownership in a particular natural resource corporation is not in doubt. If the stockholder corporation is 60% or more owned by Filipinos, all the stock held by the stockholder corporation is deemed to be held by Filipinos, Dodge Opinion No. 19, Series 1989. 3. When there is doubt as to the actual extent of Filipino equity in the investee corporation, the SEC is not precluded from using the grandfather rule, SEC OGC Opinion No. 2207 dated December 7, 2007. Who are considered as Philippine nationals? Under RA 7042, Foreign Investment Act of 1991, the following are considered Philippine nationals. 1. Corporations organized under Philippine laws of which 60% of the capital stock outstanding and entitled to vote is owned and held by Filipino citizens. Note, RA 7042 provides that where a corporation and its non-Filipino stockholders own stocks in a SEC-registered enterprise, at least 60% of the capital stock outstanding and entitled to vote of both corporations and at least 60% of the members of the board of directors of both corporations must be Filipino citizens, double 60% rule. 2. Corporations organized aboard and registered as doing business in the Philippines under the Corporation Code of which 100% of the capital stock entitled to vote belong to Filipinos. UST Golden Notes, 2019. What is the nationality of a corporation organized and incorporated under the laws of a foreign country, but owned 100% by Filipinos? 1998 Bar Exam. Answer. Under the control test of corporate nationality, a corporation organized and incorporated under the laws of a foreign country, but owned 100% by Filipinos is classified as a Philippine national. Where the grounds for piercing the veil of corporate entity are present, the corporation will follow the nationality of the controlling members or stockholders, since the corporation will then be considered as one and the same. Nationality of corporations. It becomes relevant in determining the compliance with the laws prescribing minimum ownership requirements by Filipinos for certain industries or activities under the Constitution. To protect the national economy and patrimony. Nationalized industries. A. State policy of protecting Filipino enterprises against unfair foreign competition and trade practices. B. Article 12, Section 2. Of the 1987 Constitution. Capital refers to common shares. A. Before, in computing controlling interests in a corp, the common notion was that control should be determined based on the outstanding capital stock of the corporation. Thus, both the common and preferred shares was considered in arriving at the capitalization requirements of the Constitution. B. Now, SC finally ruled that capital actually referred only to common shares since only theses shares had voting power with respect to most corporate decisions. Seat of a legal or juridical person. Albano, 2021. The seat of a legal, juridical person is the corporation's place of registry and nationality. Both voting control test the beneficial ownership test must be applied to determine whether or not a corporation is Philippine national. 60-40 ownership requirement in favor of Filipino citizens applies not only to voting control of the corporation, but also to the beneficial ownership of the corporation. Gamboa vs. Teebs. Mere legal title is insufficient to meet 60% Filipino-owned capital. Full beneficial ownership of the OCS coupled with 60% of the voting rights is required. This is a constitutional mandate, Gamboa vs. Teebs. This is important because once a corporation is considered foreign, suits instituted by it and Philippines may only be allowed if such foreign corporation is registered. Capital only means shares with voting rights to elect directors. A landmark case to determine the nationality of the corporation, it put into detail the explanation of the 60-40% of ownership provided in the Constitution. After this case, the SC stood its ground on the nationality test, liharagayud sa common shares. Principles governing a foreign corporation's right to sue in local courts, Mr. Holdings vs. Bajar, 2002. 1. If the foreign corporation does business in Philippines without license, then it has no personality to sue. 2. If the foreign corporation does not doing business in Philippines, it needs no license to sue before Philippine courts on an isolated transactions or on a cause of actions entirely independent of any business transaction. 3. If the foreign corporation does business in Philippines with a license, then it has capacity to sue. Nationalized activities reserved for Filipinos under the Constitution and special laws. A. 100% Filipino owned, 0% foreign equity. 1. Cooperatives, Article 26, Chapter 3, R. A. 6938, 2. Manufacture of firecrackers and other pyrotechnic devices. Section 5, RA 7183, 3. Manufacture, repair, stockpiling and/or distribution of biological, chemical and radiological weapons and anti-personnel mines, various treaties to which the Philippines is a signatory and conventions supported by the Philippines. 4. Mass media except recording. 5. Utilization of marine resources, Section 2. Article 12, Constitution, 6. Manufacture, repair, stockpiling and/or distribution of nuclear weapons, Section 8, Article 2, Constitution, 7. Cockpits, Section 5, p. d. 449, 8. Small-scale mining, Section 3, r. a. 7076, 9. Private security agencies, Section 4, R. A. 5487, 10. Retail trade enterprises with paid-up capital of less than $2.5 million, Section 5, RA 8762. B. 80% Filipino owned, up to 20%, foreign equity. Private radio communications network, R. A. 3846. C. 75% Filipino owned, up to 20%, foreign equity. 1. Contracts for the construction and repair of locally funded public works, Section 1, CA 541, LOI 630, except A. Infrastructure, development projects covered in RA 7718 and B. Projects which are foreign funded or assisted and required to undergo international competitive bidding, Section 2, A, RA 7718, 2. Private recruitment, whether for local or overseas employment, Article 27, p. d. 442, 3. Contracts for the construction of defense-related structures, Section 1, CA 541, 4. Under the flag law, in the purchase of articles for the government, preference shall be given to materials and supplies produced, made, or manufactured in the Philippines, and to domestic entities. Domestic entities means any citizen of the Philippines or commercial company at least 75% of the capital of which is owned by citizens of the Philippines, Section 1, CA 138. d. 70% Filipino owned, up to 20%, 30%, foreign equity. 1. Advertising, Article 16, Constitution, 2. Corporations engaged in pawnshop business, Section 8, p. d. 114. e. 40% Filipino owned, up to 20%, 60%, foreign equity. 1. Contracts for the supply of materials, goods and commodities to GOC, agency or municipal corporation, Section 1, R. A. 5183, 2. Ownership of private lands, Section 7, Article 12, Constitution Section 22, Chapter 5, CA 141 Section 4, R. A. 9182, 3. Ownership, establishment and administration of educational institutions Section 4, Article 14, Constitution, 4. Adjustment Companies Section 323, p. d. 613, 5. Culture, production, milling, processing, trading accepting retailing, of rice and corn and acquiring, by barter, purchase or otherwise, rice and corn and the byproducts thereof Section 5, PD 194. 6. Exploration, development and utilization of natural resources Section 2, Article 12, Constitution, 7. Ownership of condominium units where the common areas in the condominium project are co-owned by the owners of the separate units or owned by a corporation, Section 5, RA 4726. 8. Operation and management of public utilities, Section 11, Article 12, Constitution Section 16, CA 146, 9. Project proponent and facility operator of a BOT project requiring a public utilities franchise Section 11, Article 12, Constitution Section 2A, RA 7718, 10. Manufacture, repair, storage and / or distribution of products / ingredients requiring plug-and-play clearance, RA 7042 as amended by RA 8179, 11. Operation of deep-sea commercial fishing vessel, Section 27, RA 8550, 12. Corporations engaged in coastwise shipping Section 806, PD 1464. F. 100% foreign may own. Large-scale mining, Benito, 2020. What law determines the validity of corporate acts and contracts? The validity of corporate acts and contracts is determined by the law of the place of incorporation and by the law of the place of performance. To be valid and binding, such acts or contracts must be authorized by both laws. If valid in the place of incorporation but void in the place of performance, or vice versa, the validity of said acts or contracts is doubtful and it may not be given effect at all, without prejudice to the principle of estoppel, Section 119, Corporation Code Paris, Supra, and authorities cited, page 429. What is the doctrine of piercing the corporate veil? The doctrine of piercing the corporate veil, or disregarding the corporate fictionate permits the courts to impose personal liability on the shareholders of a corporation if the corporate form has been used to defeat the public convenience, justify wrongs, or protect fraud or crime. Paris, 1996. Bar question. A is sued in the Regional Trial Court of Manila by California Candy Corporation, a corporation organized under the laws of California for damages in the amount of 5 million pesos arising from a breach of contract whereby A had agreed to sell to said corporation 500 tons of sugar to be delivered in San Francisco, where the contract was entered into. Would you grant A's motion to dismiss the complaint on the ground that the plaintiff corporation has no capacity to sue, it not having previously obtained a license to transact business in the Philippines? State your reasons briefly. Answer: I would deny the motion to dismiss. The contract firstly was an isolated transaction. Secondly, the plaintiff was not transacting business in the Philippines, the contract having entered into in San Francisco and expressly agreed upon to be consummated there. So long, therefore, as the jurisdictional requirements are complied with, the plaintiff's suit may properly be entertained by our tribunals of justice. PAC. Vegetable Oil Corporation vs. Singson, Paris, 1996. Bar question. A New York corporation takes part in a bidding for the construction of a building in Makati. The New York corporation won the bid, but the construction company which opened the bid refused to sign the contract with the New York corporation for the construction of the building. The New York corporation then sued. As the New York corporation had not expressly obtained a license to engage in business in the Philippines, the construction company moved to dismiss the suit on the ground that the New York corporation has no right or personality to sue in Philippine courts. How should the motion to dismiss be resolved? Reasons for your answer. Answer: the motion to dismiss should be denied. To take part in a bidding does not constitute transacting business as the term is understood in Philippine law, for this is an isolated act. Paris, 1996. 1998 Bar exam. When is a foreign corporation deemed to be doing business in the Philippines? 3%. Suggested answer: the phrase doing business shall include 1. Soliciting orders, purchase, service contracts, opening offices, whether called liaison offices or branches. 2. Appointing representatives or distributors who are domiciled in the Philippines or who in any calendar year stay in the Philippines for a period or periods totaling 180 days or more. 3. Participating in the management, supervision or control of any domestic business firm, entity or corporation in the Philippines, and 4. Any other act or acts that imply a continuity of commercial dealings or arrangements, and contemplate to that extent the performance of acts or works, or the exercise of some of the functions normally incident to, and in progressive prosecution of, commercial gain or of the purpose and object of the business organization. 2002 Bar exam. What is the legal test for determining if an unlicensed foreign corporation is doing business in the Philippines? 2%. Suggested answer. The test is whether the unlicensed foreign corporation has performed an act or acts that imply a continuity of commercial dealings or arrangements and contemplate to that extent the performance of acts or works, or the exercise of some of the functions normally incident to, and in progressive prosecution of, commercial gain or of the purpose and object of the business corporation. 1998 Bar examination. What is the nationality of a corporation organized and incorporated under the laws of a foreign country, but owned 100% by Filipinos? Suggested answer: under the control test of corporate nationality, this foreign corporation is of Filipino nationality. Where there are grounds for piercing the veil of corporateity, that is, disregarding the fiction, the corporation will follow the nationality of the controlling members or stockholders, since the corporation will then be considered as one and the same. 2009 Bar exam. After disposing of his last opponent in only 2 rounds in Las Vegas, the renowned boxer Sonny Bato arrived at the NAIA met by thousands of hero worshipping fans and hundreds of media photographers. The following day, a colored photograph of Sonny wearing a black polo short embroidered with the 2-inch Lacoste crocodile logo appeared on the front page of every Philippine newspaper. Lacoste International, the French firm that manufactures Lacoste apparel and owns the Lacoste trademark, decided to cash in on the universal popularity of the boxing icon. It reprinted the photographs, with the permission of the newspaper publishers, and went on the worldwide blitz of print commercials in which Sonny is shown wearing a Lacoste shirt alongside the phrase "Sonny Bateau just loves Lacoste." When Sonny sees the Lacoste advertisements, he hires you as a lawyer and asks you to sue Lacoste International before a Philippine court. Can Lacoste International validly invoke the defense that it is not a Philippine company and, therefore, Philippine courts have no jurisdiction? Explain. Answer: no Philippine courts have jurisdiction over it, if it is doing business in the Philippines. Moreover, under Section 133 of the Corporation Code, while a foreign corporation doing business in the Philippines without license to do business, cannot sue or intervene in any action, it may be sued or proceeded against before our courts or administrative tribunal. Assignment, Guide Questions, 1. What are domestic corporations? Foreign corporation? Answer: domestic corporation are those organized and existing under laws of the Philippines. Foreign corporation are those formed, organized or existing under any laws other than those of the Philippines and whose laws allow Filipino citizens and corporations to do business in its own country or state. 2. Can foreign corporations operate in the Philippines? If yes, what are the requirements for it to operate in the Philippines? Answer: yes, they may operate in the Philippines provided they apply for a license with the SEC. Section 140 of the Revised Corporation Code of the Philippines states that foreign corporations shall have the right to transact business in the Philippines after obtaining a license for that purpose in accordance with this code and certificate of authority from the appropriate government agency. For the grant of license to a foreign corporation to legally transact business in the Philippines, the same law provides that a foreign corporation shall submit to the Commission a copy of its articles of incorporation and bylaws, certified in accordance with law, and their translation to an official language of the Philippines, if necessary. The application shall be under oath and, unless already stated in its articles of incorporation, shall specifically set forth the following: A. The date and term of incorporation. B. The address including the street number, of the principal office of the corporation in the country or state of incorporation. C. The name and address of its resident agent authorized to accept summons and process in all legal proceedings and all notices affecting the corporation, pending the establishment of a local office. D. The place in the Philippines where the corporation intends or to operate. E. The specific purpose or purposes which the corporation intends to pursue in the transaction of its business in the Philippines, provided that said purpose or purposes are those specifically stated in the certificate of authority issued by the appropriate government agency. F. The names and addresses of the present directors and officers of the corporation. G. A statement of its authorized capital stock and the aggregate number of shares which the corporation has authority to issue, itemized by class, par value of shares, shares without par value, and series, if any. H. A statement of its outstanding capital stock and the aggregate number of shares which the corporation has issued, itemized by class, par value of shares, shares without par value, and series, if any. I. A statement of the amount actually paid in and J. Such additional information as may be necessary or appropriate in order to enable the Commission to determine whether such corporation is entitled to a license to transact business in the Philippines, and determine and assess the fees payable. Attached to the application for license shall be a certificate under oath duly executed by the authorized official or officials of the jurisdiction of its incorporation, attesting to the fact the laws of the country or state of the applicant allow Filipino citizens and corporations to do business therein, and that the applicant is an existing corporation in good standing. If the certificate is in a foreign language, a translation thereof in English under oath of the translator shall be attached to the application. The application for a license to transact business in the Philippines shall likewise be accompanied by a statement under oath of the President or any other person authorized by the corporation, showing to the satisfaction of the Commission and, when appropriate, other governmental agencies that the applicant is solvent and in sound financial condition, setting forth the assets and liabilities of the corporation as of the date not exceeding 1 year immediately prior to the filing of the application. Foreign banking, financial, and insurance corporations shall, in addition to the above requirements, comply with the provisions of existing laws applicable to them. In the case of all other foreign corporations, no application for license to transact business in the Philippines shall be accepted by the Commission without previous authority from the appropriate government agency, whether required by law. Section 142 of the Revised Corporation Code of the Philippines. 3. Is the absence of a SEC license an impediment in a filing of a suit against a foreign corporation? Explain. Answer: no, the absence of a license is no impediment for the filing of a suit against the corporation for commission of illegal acts or violation of Philippines laws. Section 150 of the Revised Corporation Code provides that no foreign corporation transacting business in the Philippines without a license, or its successor or assigns, shall be permitted to maintain or intervene in any action, suit or proceeding in any court or administrative agency of the Philippines, but such corporation may be sued or proceeded against before the Philippine courts or administrative tribunals on any valid cause of action recognized under Philippine laws. Thus, it can still be sued against even in the 3. Is the absence of a SEC license an impediment in a filing of a suit against a foreign corporation? Explain. Answer: no, the absence of a license is no impediment for the filing of a suit against the corporation for commission of illegal acts or violation of Philippines laws. Section 150 of the Revised Corporation Code provides that no foreign corporation transacting business in the Philippines without a license, or its successor or assigns, shall be permitted to maintain or intervene in any action, suit or proceeding in any court or administrative agency of the Philippines, but such corporation may be sued or proceeded against before the Philippine courts or administrative tribunals on any valid cause of action recognized under Philippine laws. Thus, it can still be sued against even in the absence of a SEC license. 4. Can a foreign corporation without a valid SEC license sue in the Philippines? Explain. Answer: generally, no, a foreign corporation without a valid SEC license cannot sue in the Philippines. Under Section 150 of the Revised Corporation Law, it provides that a foreign corporation without a license is not permitted to maintain or intervene in any action, suit, or proceeding in any court, or administrative agency in the Philippines. However, as a matter of exception, a foreign corporation, although without a SEC license, such foreign corporation may sue before our courts, based on contracts, treaty stipulations, on isolated transactions, and in cases of a petition for cancellation of a trademark. 5. What is meant by doing business and not doing business in the Philippines with respect to foreign corporations? Answer: RA 5455, Section 1. The phrase doing business shall include 1. Soliciting orders, purchase, service contracts, opening offices, whether called liaison offices or branches. 2. Appointing representatives or distributors who are domiciled in the Philippines or who in any calendar year stay in the Philippines for a period or periods totaling 180 days or more. 3. Participating in the management, supervision or control of any domestic business firm, entity or corporation in the Philippines, and 4. Any other act or acts that imply a continuity of commercial dealings or arrangements, and contemplate to that extent the performance of acts or works, or the exercise of some of the functions normally incident to, and in progressive prosecution of, commercial gain or of the purpose and object of the business organization. IRRRA 7042, Section 1, F, Rule 1, that doing business does not include the following acts: 1. Mere investment, as a shareholder by a foreign entity in domestic corporation duly registered to do business, and or the exercise of rights as such investor. 2. Having a nominee director, officer to represent its interests in such corporation. 3. Appointing a representative or distributor domiciled in the Philippines, which transacts business in the representative's or distributor's own name and account. 4. Publication of a general advertisement through any print or broadcast media. 5. Maintaining a stock of goods in Philippines, for the purpose of having the same processed by another entity in the Philippines. 6. Consignment by a foreign entity of equipment with a local company to be used in the processing of products for export. 7. Collecting information in the Philippines. And 8. Performing services auxiliary to an existing isolated contract of sale which are not on a continuing basis, such as, a. Installing in the Philippines machinery it has manufactured or exported to the Philippines, servicing the same, b. Training domestic workers to operate it, and c. Similar incidental services. E. Memorized on ni attorney. 5a. Tests to determine w. In a foreign corporation is doing business in Philippines, Mentholatum Company Incorporated, versus Mangalaman. Whether the foreign corporation is continuing the body or substance of the business or enterprise for which it was organized or whether it has substantially retired from it and turned it over to another. 6. What is the residence of corporations? The domicile of corporations? Answer. A corporation may only have one domicile, but it can be a resident of several states, where it exercises corporate functions or the place where such corporation is doing business. Domicile of a corporation is the state of its incorporation. Residence of corporations. A. A corporation may only have one domicile, but it can be a resident of several states. B. Domicile of a juridical person is the state of its incorporation. C. Our laws and jurisprudence indicate a purpose to assimilate foreign corporation, duly licensed to do business here, to the status of domestic corporation. NERC, Section 22, H and I, A. Resident foreign corporation engaged in a trade or business within the Philippines. B. Non-resident foreign corporation not engaged in trade or business within the Philippines. Offshore Banking Law, PD 1034, Section 1, D. Branches, subsidiaries, affiliates, extension offices or any other units of corporation or juridical person organized under the laws of any foreign corporation operating in the Philippines shall be considered resident of the Philippines. 7. Are foreign banks with Philippine branches considered residents of the Philippines? Explain. Answer. Yes, foreign banks with Philippines branches are considered residents of the Philippines. Under the Offshore Banking Law, PD 1034, it provides that branches, subsidiaries, affiliates, extension offices or any other units of corporation or juridical person organized under the laws of any foreign corporation operating in the Philippines shall be considered resident of the Philippines. 8. Does the Philippines adhere to the Internal Affairs Rule? Answer. The Philippines adheres to the Internal Affairs Rule. Section 129, 146 in the Revised Corporation Code, RA 11232, of the Corporation Code, states, a foreign corporation lawfully doing business in the Philippines shall be bound 1. By all laws, rules and regulations applicable to domestic corporations of the same class. 2. Except those which provide for the creation, formation, organization or dissolution of corporations or those which fix the relations, liabilities, responsibilities, or duties of stockholders, members or officers of corporations to each other or to the corporation. The Internal Affairs Rule, for one, they could be governed by the laws of their state of incorporation, or by the laws of the form. Most jurisdictions follow the GR that the internal affairs of the corporations should be governed by the laws of the state of the incorporation. Others, however, have allowed their courts to apply the law of the forum in adjudicating the internal affairs of the corporation. Philippine adheres to the Internal Affairs Rule. Section 129, 146 in the Revised Corporation Code, RA 11232, of the Corporation Code, states, Section 146. Law applicable. A foreign corporation lawfully doing business in the Philippines shall be bound by all laws, rules and regulations applicable to domestic corporations of the same class, except those which provide for the creation, formation, organization or dissolution of corporations or those which fix the relations, liabilities, responsibilities, or duties of stockholders, members or officers of corporations to each other or to the corporation. A foreign corporation lawfully doing business in the Philippines shall be bound. A. By all laws, rules and regulations applicable to domestic corporations of the same class. B. Except those which provide for the creation, formation, organization or dissolution of corporations or those which fix the relations, liabilities, responsibilities, or duties of stockholders, members or officers of corporations to each other or to the corporation. State of incorporation. By incorporating in a particular state, a corporation thereby agrees that the laws of that state shall be the governing law with respect to the internal affairs of the corporation. Internal affairs refer to matters relating to the governance of the corporation as well as the rights and responsibilities of officers and stockholders. 9. What is a pseudo-foreign corporation and what law shall govern such corporation? Answer. Pseudo-foreign corporations are corporations incorporated in one state and operate in another state. Usually, the state of incorporation has less stringent laws than the states in which they operate. In Philippines, they are called foreign corporation licensed to do business in our jurisdiction. Section 146 of the Revised Corporation Code provides that, a foreign corporation lawfully doing business in the Philippines shall be bound. 3. By all laws, rules and regulations applicable to domestic corporations of the same class. 4. Except those which provide for the creation, formation, organization or dissolution of corporations or those which fix the relations, liabilities, responsibilities, or duties of stockholders, members or officers of corporations to each other or to the corporation. 10. What is the relevance of the nationality of a corporation? Answer. It becomes relevant in determining the compliance with the laws prescribing minimum ownership requirements by Filipinos for certain industries or activities under the Constitution. To protect the national economy and patrimony. 11. Explain the two approaches in determining the nationality of corporations. Answer. Under the control test, it essentials holds that when shares belonging to corporations or partnerships at least 60% of the capital of which is owed by Philippines citizens, the corporation shall be considered of Philippines nationality. This test is widely used, as compared to the grandfather rule which is used when the entity involved is engaged in nationalized activity, or in activity prescribed by the Constitution with a certain percentage of the ownership thereof belonging to Philippines citizens. Under the grandfather rule, it provides that if the percentage of Filipino ownership in the corporation or partnership is less than 60%, only the number of shares corresponding to such percentage shall be counted as of Philippines nationality. It is submitted that the control test is a more liberal approach than the grandfather rule. To settle the confusion, the SC has declared in unequivocal terms that the controlling approach is still the control test. However, the grandfather rule has not been fully abandoned. It still finds application as an exception to the general rule. It applies when there is doubt in the 60-40 Filipino equity ownership in the corporation. 12. With the seeming conflict between SEC Memorandum Circular No. 8, Series of 2013 and the case of Gumbo vs. Teebs, 652 SCRA 690, 2011, how did the Supreme Court laid to rest the conflict in the case of Roy vs. Horbaza, 88 Philippines 838, 2016? Answer. The court in its decision ruled that SEC MOC No. 8 is not contrary to the court's definition, Gumboa case, in the interpretation of the term capital. To sum up, under the SEC. Mc number 8, the 60% applied to both, a. the total number of outstanding shares of stock, entitled to vote in the election of directors and, b. the total number of outstanding shares of stock, whether or not entitled to vote in the election of directors. Section 2 of SEC Mc number 8 clearly incorporates the voting control test or the controlling interest requirement. In fact, Section 2 goes beyond requiring a 60-40 ratio in favor of Filipino nationals in the voting stocks. It moreover requires the 60-40% ownership in the total number of outstanding shares of stock, whether voting or not. The SEC formulated SEC Mc number 8 to adhere to the court's unambiguous pronouncement that full beneficial ownership of 60% of the outstanding capital stock, coupled with 60% of the voting rights, is required. Clearly, SEC Mc number 8 cannot be said to have been issued with grave abuse of discretion. SEC Mc number 8 simply implemented, and is fully in accordance with, the Gamboa decision and resolution. While SEC Mc number 8 does not expressly mention the beneficial ownership test or full beneficial ownership of stocks requirement in the FIA, this will not, as it does not, render it invalid, meaning, it does not follow that the SEC will not apply this test in determining whether the shares claimed to be owned by Philippine nationals are Filipino, that is, are held by them by mere title or in full beneficial ownership. To be sure, the SEC takes its guiding lights also from the FIA and its implementing rules, the Securities Regulation Code, Republic Act No. 8799 SRC, and its implementing rules. 13. What are the instances when the seat of legal of juridical person does not govern choice of law? Answer: instances when the seat of legal of juridical person does not govern choice of law. Albano, 2021, 1. The exception is based on contract, Tuna Processors, Incorporated vs. Philippine Kingford, 2012. 2. Another different source of exception, treaty stipulations, La Chemise Lacoste vs. Fernandez, 1994. 3. In Eastboard Navigation Limited, vs. Ismael & Co., Incorporated. 102 Phil 1, we recognized a right of foreign corporation to sue on isolated transactions. 4. In General Garments Corporation vs. Director of Patents, 41 SCRA 50, we sustain the right of Puritan Sportswear Corporation, a foreign corporation not licensed to do and not doing business in the Philippines, to file a petition for cancellation of a trademark before the Patent Office. A foreign corporation may file suit, enforce a judgment in the Philippines despite the fact that it is not registered as doing business in the Philippines. The recognized instances of binding contractual provisions and treaty stipulations represent recognized exceptions.